Good morning again. I'm still Thomas Ragatz, but I am now a Special Assistant Steele County Attorney. And I'm here now to talk about urine testing, but I want to start before I do that by addressing two constitutional arguments that Mr. Trahan didn't make, but that Mr. Thompson does. And those are unconstitutional condition and violation of the Fifth Amendment. The problem with both of those arguments is that they prove too much, because if there was an unconstitutional condition here, or if there was a Fifth Amendment violation, then you couldn't have any civil implied consent proceedings or sanctions either. To rule in Mr. Thompson's favor on either of those issues would require overturning Bernard and Brooks and all of the civil cases, because there's no case law, again, that says even though there was a Fifth Amendment violation, we can punish you civilly, we just can't do it criminally. Again, the proper analysis here is the Fourth Amendment under Camara and the balancing test that is set out in Knights and the other cases. So a lot of the same arguments I've already made for the balancing test apply here, except, of course, we're talking about urine now instead of blood. And urine testing is certainly less invasive than blood testing. Urine testing is more like breath testing in that it simply involves the collection of a naturally expelled biological material. We're not talking about drawing anything out of your body. We're just talking about collecting something that was going to come out anyway. Now, the obvious rebuttal to that, and the problem here, is the privacy interest. And that seems to be the focus here, that the invasion of privacy in urine testing and urine collection is so great that that tilts the balancing test against the state. But I'd refer this court to the Vernonia versus School District decision. In that case, the United States Supreme Court upheld urine testing and said, under the conditions set out here, collecting a urine sample is really no more invasive than using a public restroom. The police have to stand behind the male, the woman's allowed to go into a stall, and the same certainly could be true in Minnesota. This court could offer guidance to the police that is the condition under which urine testing should be done. And if there is a case where urine testing is done in an especially invasive way, well, those can be dealt with on a case-by-case basis.
Factually speaking, how was the urine testing done in this case? Was it done with the police officer standing behind? Was it done in a stall? I'm just curious how invasive it was here.
Well, there wasn't any urine testing here, and I think that goes to my point, too, that these are test refusal cases. So we're not talking about any actual invasion of privacy. We're just talking about perhaps someone thinking, I really don't want to do a urine test because I think it's going to invade my privacy. But if that's the situation, then you can agree to a blood test instead. You have to be given an alternative. So just like if you're a person...
Counsel, before you move on, are there any administrative standards as to how a urine test would be administered that we have in the record to look at?
There's nothing in the record like that, Your Honor. And I would point out that it is Mr. Thompson's burden to establish unconstitutionality. So any lack in the record here should be held against him, not against the state. And again, I think this court could certainly offer guidance to the police as to how urine should be collected to avoid invasions of privacy in the future. So it comports with Vernonia, where again, it was no worse than using a public restroom. And again, if you're one of those people who can't stand the thought of using a public restroom with anyone else within 10 feet, well, then you can do a blood test instead. You have to be given an alternative. So there is no necessary invasion of privacy with urine testing. And again, the issue here is not forcing someone to give a urine test. The issue is criminalizing the refusal to provide a urine or blood test when you've made the decision to drive and when you've been lawfully arrested. And as I was saying, if there are situations where urine is obtained in an inappropriate manner, those can be dealt on a case-by-case basis. We've all seen the cases where the police engaged badly in a massage parlor sting, and the evidence has been suppressed. But that doesn't mean we say you can never do massage parlor prostitution stings. That just means we say next time don't expose yourself quite so much, or don't do the things you shouldn't have done here. That doesn't mean the whole process is thrown out.
Counsel, now that I've completely confused the two cases with the urine in the first case, but not in the second case, the question I would ask you is, does it matter from the state's point of view how the urine test would have been conducted? Or is the state making a categorical argument that urine in its very nature is more like breath and perhaps less like blood or some other more invasive test?
Your Honor, I am arguing that urine is more like breath than blood. But I am not saying that no matter how urine is obtained, it's constitutional. I'm saying if there is a case where a same-sex officer isn't used, and it's done in a distasteful, exploitative, shaming way, that could be a problem. If you were made to urinate in the middle of Hennepin Avenue on a weekday, then the evidence certainly could be suppressible. But that doesn't mean that we should say you can never ask for urine in the first place, much less that you shouldn't be able to criminalize urine test refusal when the person has no reason to think that they're going to be mistreated by the police in terms of the ultimate collection of the urine test. And again, importantly, where the person always has the alternative of saying, no thank you, I'd really rather not pee in front of you or near you, let's just do the blood test instead. So there's always that alternative. We don't have the exigent circumstances argument in this case, but there is still the good faith argument. And I will come back to that to try and expand on my position a little more. I'm not saying here that that you shouldn't expand on linguist and apply the good faith exception in ways that you haven't in the past if you feel like that's what's necessary. I'm saying you don't need to do that because I'm saying this is like linguist in that it involves suppression of evidence. And I think Bernard is really the key to that argument because
it's interesting you mentioned Bernard. That is kind of the 900-pound elephant in the room, and I'm wondering, does your analysis here about urine versus breath and blood, is that affected by, of course we don't know what the Supreme Court's going to decide, but obviously if the state does not prevail in Bernard, doesn't that undercut your argument here?
It certainly would, Your Honor, and I've read the Bernard oral argument transcript, and I think it's very hard to predict what the U.S. Supreme Court's going to do. I think there is a decent chance, at least, that breath will be upheld. I'm not sure what they're going to do with blood and urine up there. They may not decide it. Maybe we'll have a 4-4 tie, and it'll decide nothing. We don't know. We'll have to wait and see what happens with that. I think I can address some of the concerns that were raised at the United States Supreme Court level about Bernard, or about testing in general, and that the amici and the defense have raised here, one of which is the whole slippery slope idea, which if you're going to allow this, next thing you know, we're going to have implied consent for texting while driving. But we're really talking about a unique area here because of the combination of the implied consent, which diminishes the expectation of privacy, and because of the natural dissipation of the evidence. Now, yes, under McNeely, that alone isn't enough to justify a search, but it certainly is an appropriate factor in the balancing that has to take place under the Knight's decision.
Well, Counsel, now that you brought up the texting example, I'm going to ask what the state's view on that. I found that question by Chief Justice Roberts to be fascinating, which is, suppose there was an implied consent law that said, because texting is a huge problem, as we've read in the paper, and suppose there's an implied consent law that says you give permission for an officer upon reasonable, probable cause that you're texting while driving to look through your cell phone. What would be the state's position to a hypothetical like that?
Well, I don't want to commit myself to anything because I think we might well say in the balancing that would be okay too. But it would be a very different balancing equation because I think the critical distinction is there is no element of time there. The state can seize your cell phone, put it in one of those little foil-lined boxes so you can't remotely erase it, and then they can check it later. Here, if you wait till later, then at best you're going to have to do extrapolation math to figure out if the person was over 0.08. And at worst, you might not be able to do that. If you wait till the next day, like you could with a cell phone, then you've got no evidence. Also, forced testing of a cell phone isn't going to endanger anybody the way a forced blood draw can. And really, a forced blood draw is the only forced test we're talking about. It's not possible to force someone to blow into a tube enough for a breath test if they don't want to. We don't force people to urinate. I don't know how you do that except just waiting, but even then, it's hard to force them to pee right into the cup that you want them to pee into. So forced blood draws is really what it comes down to, and that does raise the danger of injury, of hospitals not wanting to participate, and those sort of issues just don't come up in the cell phone context, or really in any other context that people have mentioned in terms of the slippery slope of eviscerating the Fourth Amendment here. We're talking about a very particular area. And again, I think it is important we're not talking about a suspicionless search. And again, in this case, as in Mr. Trahan's case, the defense has never cited a situation where if you'd gone to a judge and said, hey, I pulled this guy over, here's what I saw, I want a warrant for chemical testing, the judge would have said, no, that's not enough. I mean, this is so routine. Police are trained. We're not talking about lay people off the street. That this is such a routine process that it does eliminate a lot of the discretion that the court was concerned about in Kamara and Skinner and some of the other cases. And again, I think Knights is the critical case here because Knights also involved searching for evidence of a crime. It wasn't just some other purpose. So really the only difference here between Mr. Thompson and Mr. Crane's case is the less invasive nature of the urine search. So my argument is if you affirm blood, then you should certainly affirm urine because it's less invasive. But even if you decide that blood crosses the line because of the invasive nature, you should nevertheless affirm the urine testing because it doesn't have to be an invasion of privacy. And I'm sorry to be a broken record, but again, we're talking about not even forcing a test. We're just talking about criminalizing test refusal under the implied consent situation. So going back to good faith for a minute, because that is the other issue that overlaps on both of these cases. My argument again is that Bernard is critical here because Bernard says if you have a warrant, then test refusal can be constitutional. So if you have a warrant and then ask someone for a urine test and they say no, they can be criminally punished for test refusal. So the difference is whether you have a warrant or not, just like the difference in a marijuana seizure case may be, did you have a warrant or not? If you did, then the statute's constitutional is applied to you, you can be convicted. If you didn't, well then the evidence is suppressed, or to look at it in just a flip side of the same coin, the statute's unconstitutional is applied to you, and you can't be convicted.
Counsel, does the special assistant Steele County attorney have any cases to cite on the subject that the assistant Ramsey County attorney did not?
There aren't any cases that are factually on point here, but there weren't any cases that were factually just like Lindquist.
All right, then we're going to need to discuss concepts. Let's say you've got a law regulating demonstrations, and the cops arrest somebody for picketing. In the face of it, it looks like he's violated the law. Well, it turns out the law is unconstitutional as applied in violation of the First Amendment. Are you still saying that conviction needs to be upheld because the cop arrested somebody in good faith?
Well, I guess it would depend if we had a situation where the cop was relying on published case law, which then changed after the arrest, because that is what we're talking about here. The published case law.
Sure. Assume that the Minnesota Supreme Court said that statute was constitutional as applied, and the U.S. Supreme Court says no. Do you then go back and say, well, the cop arrested in good faith?
Well,
so the person's still convicted of an under a statute that's unconstitutional as applied to that person.
Well,
where is the logic in this?
That is not an argument that Mr. Thompson has made, so I'm trying to think on my feet here, but I think the difference between those two is...
Well, yeah, but it's an argument that the state has made.
Right, but so the difference between your hypothetical, which I haven't thought about until right now, is in your hypothetical, the conduct is constitutional because the previous statute was unconstitutional, so this picketing behavior is okay. Possessing methamphetamine is never okay. The question is whether it was seized properly or not. And similarly here...
Yeah, but counsel, in this case, the defense is not seeking to suppress the fact that the defendant refused the test. In fact, they're extolling the fact that the defendant refused the test and saying he had a constitutional right to do that. This is not a suppression case, is it?
Well, I think it is, Your Honor. I think it's not on its face identical to drug suppression cases, but because this case all comes down to whether there was a warrant before the evidence was gathered or whether there wasn't, it's just like a drug case in that way, because if there was a warrant before you asked the question and got the test refusal, you could use the test refusal. Because there wasn't a warrant, you can't. Just like if you had a warrant and got the meth out of someone's house, you can use it against them, but if you didn't, you can't.
Yeah, but when the meth is suppressed, it's not suppressed because the meth statute is unconstitutional. It's suppressed because the evidence was procured in violation of the Constitution.
Well,
Isn't that a really critical difference?
I think that basically you could say the meth statute is unconstitutional as applied to that person because the meth was gathered illegally. Same thing here. The test refusal statute is not facially unconstitutional. It's only unconstitutional as applied to Mr. Thompson because you should have had a warrant before you asked for the test refusal. And I think the underlying theory behind the good faith exception certainly applies here, because we don't expect police officers to be Nostradamus. They can't predict changes in the law. No one's ever said the police officers should have known to do something differently here. They did everything right. And unlike a First Amendment situation, we're not talking about conduct that can't be punished under any situation. We're just talking about whether the conduct can be punished if you get a warrant properly first.
Counsel, I'm going to ask you a question based on precedent that actually undermines the application of the good faith exception here, which is it was a different situation, but it's almost the exact opposite of what the state's arguing here factually, which is in a recent case, the Horse case, the argument was made, you can't convict me because some of the evidence that wasn't used in the case was illegally procured. And we said, that's not what the exclusionary rule is all about. The exclusionary rule is about excluding evidence. And of course, we've also said in other cases the good faith exception, the only thing about the good faith exception is it's an exception to the exclusionary rule. So the question I would ask is, if it's not about the conviction itself, which is what we said in Horst, and it's all about the evidence, what evidence is there here to be suppressed, and how does the good faith exception fit under the Horst case?
I know the Horse case well, Your Honor, and I think this is very different from that case, because here, if Mr. Thompson was prosecuted for test refusal, the evidence the state would produce to a jury is he refused to test. And we have to prove beyond a reasonable doubt he refused to test. If it's kind of wishy-washy, well, then maybe we can't prove beyond a reasonable doubt that he was really refusing. Maybe he was just equivocating and wanted a little more time. So the evidence we have to prove to be an element to the jury is the test refusal, and that's what essentially would be suppressed here, because the ruling would be you can't use this test refusal because you didn't have a warrant in the first place. Whereas under Bernard, if you had a warrant, then there'd be no problem with using the test refusal.
No, it wouldn't be suppressed. In fact, we would have to rely on it in our holding, that the test refusal statute is unconstitutional as implied. We wouldn't disregard it. It's critical.
Well, you couldn't use it against Mr. Thompson, the same way you couldn't use meth against someone if the meth was illegally seized. And again,
I'm tempted to say you're beating a dead horse, but
I think I am, but I think that's the only analogy I can give you here, is that you can't, I think that you are suppressing the test refusal because under Bernard, with a warrant, the test refusal would have been okay. So we're not talking about facial invalidity, and I have nothing else to say on that. So unless the court has additional questions, I will be back for rebuttal.
Thank you, counsel. You have 14 minutes for rebuttal. Mr. Kohler.
May it please the court, opposing counsel. My name is Dan Kohler, and I represent the respondent, Ryan Thompson, in this matter. My understanding of the thrust of the state's argument in this case is that they're asking this court to treat every Minnesotan that gets behind the wheel of a vehicle as a probationer. And my argument would be that driving does not put you in the same situation as a probationer. All of the special needs cases have one thing in common other than Griffin and Sampson and Knights, and it's that they're not captioned as state v. blank. All of the special needs cases are not criminal cases, with the exception of the probationer cases. And the probationer parolee cases have that key point where the driver, or not the driver, but the probationer was convicted beyond a reasonable doubt, maybe by a jury, maybe they pled. But that's where the diminished expectation of privacy comes from. Nowhere in those cases do I see the court relying on the fact that they signed a consent decree with probation. It's the fact that we think they're more likely than the average person to go ahead and commit a crime. That's why they're under that increased scrutiny. They've got more reason to try to hide evidence of further crimes, because that additional evidence is going to go in front of another judge where the standard isn't proof beyond a reasonable doubt, and where they don't have the right to a jury because it's a probation or a parole violation proceeding. That's what happens in a probationer's case, and that's why the courts have looked at that from a reasonableness standard. The reasonableness standard here is only appropriate if we decide that this is special needs, and I argue that it is not. or if this court decides that every Minnesotan that decides to drive, which is probably 99% of everybody over the age of 16, is in the same position as a probationer. And I just don't see how that makes any sense at all. So in terms of special needs, I just don't see how this can apply, how a urine test or how a blood test can be treated as a special needs, because as was said in the brief, it's being conducted by law enforcement agents, or at least at their direct command, and it's being done specifically for one reason and one reason only. The reason we're here today is that they wanted evidence to use in a criminal proceeding. We're not talking about license revocations, and for the purposes of my argument, I'm assuming that it's perfectly valid to not only revoke somebody for a longer period of time if they refuse, but to tell them that. To tell them, we're going to revoke you for 4 times as long if you refuse to take this urine test or this blood test. Will you submit to the test?
Is it your position that the probationer's awareness and agreement to the search requirement in the probation order was not relevant to the court's consideration in Knights?
I don't think that it is. I mean, the simple fact is that what is a probationer going to do but agree? Go to prison? I mean, that's the definition of an adhesion contract. I mean, they were definitely made aware that searches could be made either on reasonable suspicion or no suspicion at all. But that's absolutely not what we consider to be consent. And I know in Griffin and in Knights, there was no real discussion about the fact that they consented to these terms. All of the discussion was about the fact that this is being done because they're at an increased risk of committing new crimes for the reasons I talked about. And specifically in Griffin, the court even pointed out that these searches aren't being conducted by law enforcement. They're being done by parole officers. And they're not expected to know the nuance and the intricacies of Fourth Amendment jurisprudence like law enforcement are. So when a parole officer is executing this search, they're not actually law enforcement. And yeah, it could very well be used in a criminal case. And a prior criminal case is the whole reason they're on probation in the first case. But that's the only special needs cases that I could find where you would actually see a caption of state v. person. All of the rest of these cases are civil cases. Law enforcement aren't conducting the searches. They're absolutely suspicionless. There's all sorts of provisions where law enforcement and prosecutors don't even have access to this evidence. Skinner was concerned that their holding would change if it turns out that this evidence was being routinely forwarded to prosecutors.
What about Maryland versus King, the buccal swab from Maryland? I mean, obviously, state was in the caption of that one. What's different about that?
Maryland v. King is I don't think anybody can agree exactly what happened in that case. I believe the basic premise of King was that it's for identification and identification only. My personal reading of that case is that the court got to where they wanted to get because they were anticipating improvements in technology when it comes to DNA testing. Justice Scalia's dissent was pretty scathing, but pointed out that it takes some time to do a DNA test now. The opinion itself, the majority opinion, read as though they were assuming we could have a test within several minutes. And I believe the government actually made that argument at oral arguments. We're getting to the point where we can get DNA results back in a couple minutes. It's going to be even better than fingerprinting. And that's what King was about. It said that it would perfectly fit within special needs, but it's not a special needs case. I imagine that the opinions went through several drafts and redrafts as the dissent and the majority went back and forth. But that case, I don't think that's applicable here just because this is unequivocally not for the purposes of identification or any other sort of special needs. Whether or not King was a pretext to actually get criminal evidence, the holding itself said that it was for ID. And I don't think there's any argument that we can ID my client, and that's why they wanted him to either urinate or submit to a blood
Counsel, what if the legislature passed a statute along the line of Maryland versus King and said we have an important interest in public safety and the way we run our prisons and jails to know whether somebody is arrested as under the influence of chemical intoxicants. And so we're going to require that when somebody is booked for whatever crime, that they take a blood, alcohol, or breath test, or blood, urine, or a breath test. Would that kind of statute be constitutional?
I don't think so, as you just described it. If the statute said they had to submit to a preliminary breath test, the little handheld PBT, I think that might very well pass muster, because the goal would be safety of the jailers, safety of other people in the jail. The goal isn't to obtain evidence. But if it said you can force somebody to urinate or you can stab them with a needle, besides the practical problems with doing such a thing and the fact that you're not going to really get an instantaneous result from a fluid sample, that may be appropriate in a breath test case, but I think the invasion of privacy and just the practicalities of it would be a bit too much when they were saying blood or urine. Because again, breath would be a very easy way to do it, and as a practical matter, that is exactly what happens. When somebody's arrested for an alcohol-related offense, they're not released until they blow zeros more often than not. And that's just on a little handheld device. It doesn't have much evidentiary value. It's really only useful to say, is there a presence of alcohol or an absence? And they're just looking for that absence.
Counsel, on the search incident to arrest, this is really the pressure point for me in the case. I didn't join Bernard. I dissented from Bernard. But when you read Bernard and you read the majority opinion in Bernard, I have a very hard time distinguishing between urine and breath. Both require a defendant, a suspect, to produce biological material. I suppose there's a different privacy interest, but in both cases, as opposing counsel said, the defendant can just refuse to cooperate, unlike being stabbed with a needle. And so, help me understand how urine is different from the breath test in Bernard.
Well, in terms of invasiveness, I can't imagine a more invasive search than to catheterize somebody to get urine, because that's literally what it would take. And if this court held law enforcement can obtain these without warrants, there's nothing stopping them from doing that. I mean, urine just is such a fundamentally private act. Like, imagine going to the hospital or the clinic. Just a reasonable person goes in to get a reasonable physical, and the doctor orders blood and orders urine. A male or female is going to come into the exam room to do the blood draw. It's going to be over in 5 minutes. Then the person is going to go into a private little room with a little cubby on the wall in order to submit the urine sample. They're not going to do it in the presence of anyone. If they ever did it in the presence of anyone, it was going to have to be somebody of the same sex. And some people can't even do it unless they're totally alone. I mean, that's the privacy interest.
But here's the problem I'm having. I mean, Riley, I think it's our case in Riley, where they were looking for unique markings on the suspect's penis. We approved that, and we said that was fine. It didn't offend the Fourth Amendment. And my problem with this is if you take Riley and you put it next to Bernard, I don't know how you can treat urine differently than you can treat breath. Maybe I'm wrong about that, and maybe you can convince me otherwise.
Well, and obviously I can't be right about that. It's up to you and your colleagues. But no, it's hard to, the courts that have grappled with this issue have all universally said, starting with Skinner, I mean, urine testing, this implicates an absolutely fundamental privacy right that we have long recognized that society sees that as reasonable. And the Fifth Circuit talked about the fact that when we even talk about it, and I've just used the word "it" 3 times, we use euphemisms. Like it's not the type of thing that's discussed in polite conversation. I can't do it in front of my wife. And I know there's a lot of people that can't do it in front of their partners. That door stays closed. That's how big of a fundamental privacy right this is. It would be deviant for me to walk up to somebody and demand that they stand there and micturate into a cup for me. If an officer is going to do that, and again, the context is crucial, because obviously a body cavity search, I would say, is clearly infringing on more of a privacy interest than urinating. But the context is law enforcement specifically looking for criminal evidence after they've arrested somebody. And that's what excludes the special needs doctrine, and that's why this court shouldn't go down that road of saying, well, we're still going to assess whether this is reasonable or not. The fact is that what the court should simply be doing is saying, because it's law enforcement looking for evidence, and because it's already been established numerous times to actually be a Fourth Amendment search, what we need to do is enforce the warrant requirement. That is why we have neutral magistrates. That's one of the core roles of the judiciary. And the vast majority of the time, if a warrant is requested, it is going to be granted. It's the same way across the board. I don't have stats, but I'm assuming 90 to 95% of all warrants are granted. The reason we have neutral magistrates reviewing that process is for the edge cases where the officer is getting just a bit too overzealous. Imagine an officer that just spent 4 hours cleaning up a 4-fatality drunk driving accident and at the end of his shift pulls somebody over. He's going to run that guy in for DWI no matter what. He's really jacked up. He's doing his job. That's going to be the situation where a judge can step in and say, you know what, I'm not actually seeing probable cause when it's just bloodshot, watery eyes. And then you've got the situation where you've got citizens that don't trust law enforcement, where they want to say, I know you think you have probable
Counsel,
cause. I want to hear it from a judge.
I'd like you to, I'm very interested in your response to Justice Strauss's question. I share the same concern about the search incident to the arrest and trying to distinguish what makes urine different than breath. And in my questions of opposing counsel, and I may be mixing up the cases, but the administrative standards of how a urine test would be administered, should we go that direction, isn't before us. Am I correct about that?
The court could take judicial notice of it. There's one administrative rule.
But there's no evidence that has been submitted by either party, is there?
No.
Okay, so, all right, and the administrative rule you were going to reference?
Yeah, and I don't, off the top, I know it's 7502, colon, something, 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 something. I don't remember it off the top of my head. I believe it's 0400. But the only rule that has been promulgated is that any person may administer a urine test. And that's it. It is wide open. In the amicus briefs, the court was able to see there's been situations where law enforcement have been demanding urine tests at the side of the road. It's telling people refusal to take this test is a crime. Will you urinate on the side of the road right here? They can do it they could do it in a beer bottle. I mean, if they wanted to. There's literally no administrative guidance like there is for blood tests as there is for urine tests. And again, to your point and Justice Strauss's point, I don't know how else to emphasize just how private society does consider urination and why there is such a privacy interest. Again, it would be different if every driver was a probationer or was a parolee, but I'd be shocked if this court was willing to go that far and treat getting behind the wheel as the same as having been convicted of an offense.
I guess I'm just sort of thinking about the blood draw. There are standards of how that's administered. If there were standards for how a urine test would be administered, then we could make more easily the kind of determination that you're making, but we really don't have that here, and that's concerning to me.
Well, and that's the thing with the lack of standards or some of the problems the state has raised with the statute. I mean, the legislature can't legislate itself into a box to bind to this court's hands. I mean, the current state of the law is that if you refuse a urine test, a blood test has to be offered. The legislature could repeal that tomorrow. So I don't think that directly informs much of the constitutional analysis that this court needs to perform. This court's job is to interpret the Minnesota and the U.S. constitutions and say, this works, this doesn't. The legislature's job is to make statutes that actually comport with the Constitution. And so the fact that they haven't passed any sort of regulations, or rather, the only administrative rule on the books is that anybody can administer a urine test, is troubling, but it's something that could be easily rectified by the rulemaking process or by the legislature.
Counsel, you're not making any argument in this case that the Minnesota Constitution affords any greater protection than the United States Constitution with regards to the subject today, are you?
I would be delighted if the court would rule that way.
I appreciate that, but that argument is not before us, is it?
It was, I believe it was raised, and I know it was raised in this brief. I'm basically treating...
Was it litigated below? Was the state constitutional argument litigated below?
When the argument was raised, it was raised as Fourth Amendment and Article 1, Section 10 of the Minnesota Constitution.
Okay.
The arguments weren't treated any differently beyond that point. They were simply both raised. This case would be an opportunity because the law is unsettled right now, what with Bernard, Birchfield, and Bayland. But this court does have a proud tradition that I know it's aware of, Asher and Askeruth and Curtis, of specifically situations dealing with drivers providing those extra protections, keeping Minnesotans freer than they otherwise would be under the U.S. Constitution. And I don't think that there's anything precluding this court from ruling that way, although right now we simply don't have much by way of guidance to even distinguish this case from anything that's currently published by the United States Supreme Court. One thing that is interesting, the state brought up the fact that you can't normally use somebody's refusal to submit to a warrantless search as evidence against them. I mean, this court has found as much in Larson and Jones. All of the federal circuits seem to find the same way, and yet the state is arguing that that supports their argument. I don't fully understand how they get from A to B in that respect, but I don't know why we're carving an exception or attempting to carve an exception for one specific crime when the standard rule is that you cannot use somebody's refusal to submit to a warrantless search against them. Neville arguably stands for that proposition, but I'm not sure what the current status of Neville actually is. It wasn't raised as a Fourth Amendment case. It was raised solely on Fifth Amendment grounds, so it wasn't actually addressing demands to execute warrantless or even warranted searches. And McNeely would apparently seem to call at least part of the holding in Neville into doubt, in that Neville was assuming that these tests could be compelled. After McNeely kind of reevaluated Schmerber and gave us some additional guidance on that, I don't know if Neville survives. That may be an issue that this court is going to need to address at some point in the future. But a decision in this court simply finding the warrant requirement applies to urine and to blood, therefore, get a warrant or don't get the test, and you can't use the person's refusal against them, would be in compliance with all of our prior case law, including Bernard and including Brooks. And when the state argues that these refusal laws are necessary in order to protect public safety, I'm again wondering how they're getting from point A to point B with that argument. Refusals are taking place after somebody's already been taken off the road. They've been arrested. They're going to be charged with driving while impaired, so we've got that initial component of public safety right there. The only question is how much evidence are we going to have to use against them? And the state isn't even using all of the coercive aspects of the implied consent law that they could. I mean, this court in Brooks held that the implied consent law is not coercive. Telling somebody refusal to take a test is a crime is not coercive in and of itself. So that's not helping public safety in any way. And we're not telling drivers it's a more serious crime. We're not telling them the license revocation is going to be 4 times longer if you refuse. I mean, we could make our law a lot more coercive than it actually is and still be constitutional. But in terms of urine tests and blood tests, criminalizing the act of saying no is that one step too far. As Justice Strauss mentioned, very easy legislative fix, you can make it an enhanceable offense to refuse to submit to a warranted search. And that's going to have the added benefit of promoting law enforcement's use of the warrant requirement, the warrant process. We've had telephonic warrants in Minnesota for a long time. Now we've got electronic warrants. Other states can get warrants in as little as 5 minutes. In some of the amicus briefs that were submitted to the U.S. Supreme Court in Bernard, they noted that in Wyoming you can get one within 5 minutes. We've got extremely literate, well-trained officers in Minnesota. They just want to follow the law. And we're at a point in time where it has never been easier to get a warrant. I mean, one button on a smartphone and you're calling an on-call judge. The next button is recording it. You've got a third button to transcribe it. And with a couple little extra fiddling, you can send that anywhere you want. Like, we should be emphasizing the use of the warrant process for all of our law enforcement agents. And if anything, from a policy standpoint, this is the right kind of case to start making that emphasis. Because this is the type of situation where I honestly believe the vast majority of people are going to continue to consent, even if the refusal law is unconstitutional. I'm sure our refusal rate will go up somewhat, but a lot of people were trained to honestly believe that when an officer tells you to do something, you do it. A lot of people that get arrested for DWI are thinking right away, man, it was dumb to drive, and they just want to fall on the sword and be done with it.
Well, maybe there will be people who consent, but if they consult with counsel, wouldn't the routine advice then be don't consent? I mean, right now, that's a complicated question on what to counsel clients because of the refusal law. It becomes a lot less complicated, doesn't it, for counsel?
At this point, it's very complicated, yes. If we were in a situation where it was unconstitutional to refuse to submit to a blood or urine, but, vice versa, if the breath was constitutional, but the blood and urine was unconstitutional, that's still a horny question. I think statistically, maybe 15% or so of all drivers, maybe a few more, that are arrested actually do consult with counsel. If this court struck down Minnesota's test refusal law, or if the U.S. Supreme Court does, I would be advising people, refuse unless you think you're absolutely going to pass. I mean, and that's a time-honored tradition. If somebody calls me and says law enforcement are on my doorstep and they want to come in, I say,
and they want to talk to you they want to talk to me about a crime that I've committed. Your routine advice is keep your mouth shut, right?
Yeah. I mean, and that's the whole cornerstone of our adversarial process. I mean, law enforcement have every right to ask, and private citizens have every right to say no. And when a judge signs a warrant, law enforcement have the entire apparatus of the state at their disposal to bring in 24 agents to toss somebody's house. But you can't walk into somebody's house and say, we've got a warrant, point us to where the drugs are. They still got to find them. And it's a process that's been in place for 250 years, and it's a great process that emphasizes that the whole criminal justice system isn't just about the outcome, it's also about the process involved. And when you've got a driver like Mr. Thompson who just wanted to know what his PBT result was, and the officer wouldn't tell him, and he got frustrated, and he said, I'm not taking any more tests then. I mean, he was basically saying, I don't trust you. If the officer had called the judge and got a warrant, 20, 30 minutes later even, had said, judge just said you got to give it to me, almost a certainty Mr. Thompson would have said, all right, let's do it. Notwithstanding the fact that just telling him I'm getting a warrant for a blood test would have probably gotten my client and many other people to say, you know what, forget the blood, I'll blow right now. Thank you.
Thank you, counsel. Mr. Ragatz, you have 14 minutes.
We are not asking for every driver to be treated like a probationer, because this only applies to lawfully arrested drivers. This is not a suspicionless search. If you were not lawfully arrested, you can refuse to your heart's content and you cannot be convicted. So that's a difference here. Now, counsel says that reasonableness only applies in a special needs situation, so here you should say, well, it's not special needs, so we don't have to do any sort of reasonableness balancing. That's the end of the case. But it is impossible to square that result with Knights, because Knights was not a special needs case either. Knights engaged in the balancing. Now, counsel says, well, the diminished expectation of privacy here shouldn't be considered the same as in Knights. But that's just part of the balancing test then. So under Knights, you have to do a balancing test, and there are real costs here. Counsel has frankly admitted that he would advise clients to refuse tests. The problem is, under Minnesota law, you cannot now wait until someone refuses a test and then get a warrant. So that's going to mean that in every case where you want blood or urine, you have to get a warrant first. And that will be an extraordinary cost. And there may be many cases where breath won't do, because if there's any suspicion of drugs, and not alcohol, you need blood or urine. If you don't have a certified data master operator, you can't do a breath test. If you don't have access to a working data master, if you have a driver who's got asthma or has some other reason they can't produce a breath sample, there are many situations where blood or urine will be required, perhaps more so now with marijuana being legal in other states. There are going to be lots of situations where you need blood or urine, and under Mr. Thompson's argument, you're going to have to get a warrant before you even ask for refusal in every single one of those situations.
Counsel, in states that don't haven't criminalized test refusal, what does the empirical data show as to how many more drivers, percentage-wise, refuse to consent to test?
I don't have that information in front of me, Your Honor. In Bernard, you recognize some studies that are cited in Bernard, I believe, that show that test refusal is a valid tool to help fight drunk driving, and that I believe there's a study cited there, or perhaps in my brief, that most other countries have test refusal statutes, and the places where there isn't such a statute, you're going to have more test refusals, because why not? Why would you ever consent if you can make it harder to get a conviction by saying, nope, you got to get a warrant and take me to the hospital and delay things and et cetera.
Well, when the cops show up at your door, if you consult with counsel, typically counsel will say, don't talk. But there are many, many people who give interviews when cops come to the door. What is different about breath testing? Why should we believe we're just going to have massive amounts of warrants if we don't have the test refusal law?
Well, if you look at the Department of Public Safety's website, you can see the numbers on test refusal, and they are not insubstantial, and as counsel has stated, they've been going up, and they certainly would go way up if there was no cost to test refusal at all, if it could only make your conviction more difficult to get. And I'm not sure that most people who talk to the cops when they probably shouldn't have, do talk to a lawyer first. Whereas in the implied consent setting, you have to be told you can talk to an attorney, and here, I'll even give you a phone to do it, and I'll wait 45 minutes if necessary while you call various attorneys and wait for them to call you back. It's not the same as with a house and or just a search of or questioning somebody on the street. And I think that's where Neville gets to be important again, because Neville says driving is different. Neville says you can use test refusal criminally, which you obviously couldn't do in a non-driving situation. And counsel actually conceded in the Thompson brief that you can use criminal test refusal. You can use test refusal in a criminal case. Their argument is you can't make it the crime itself, but they concede in their brief that you can do that under Neville. And Neville, again, hasn't been overturned, and certainly there's no danger of the civil implied consent statutes being overturned. Those have been affirmed many times, and if you take counsel's argument to the logical conclusion, you can't do anything civilly for test refusal either, because if you have a Fourth Amendment right...
I wonder if you are planning on talking about search incident to arrest, and if you would, I'm interested in the state's response to the argument that a urine test is more like a blood draw. It's not minimally intrusive, it's physically intrusive, and talked about catheterization of individuals to compel a urine sample.
Well, I've never seen or heard of, and there certainly has been cited, a case that involved catheterization. I mean, the typical situation is you've got a cup and they pee into it. You'd have to obviously take them to a hospital or something, I would think, for catheterization. And again, that could be a case that would be dealt with if it ever occurred, just like a bad massage parlor search, when it happens, can be dealt with on those facts. We, again, haven't seen any citation of a situation where if you had gone to the judge and said, I want a warrant for a urine test or a blood test, the judge would have said, no, you don't have enough. This is so routine, and counsel's actually acknowledged how routine this is and how it would be so easy to get a warrant. Well, the fact that it would be so easy to get a warrant cuts against requiring it, given the cost that would be involved. That's under counsel's assumption. I'm not sure it would be that easy to get a warrant. Again, the 8th district has 11 judges, so those judges would have to be on call every week and a half. And there certainly could be a significant time component in getting a warrant. And again,
so can I just, on this privacy thing, just as a matter of common sense, we're all breathing here in this room together. when we need to use a restroom, we're going to go out several doors and into another door and shut some doors. I mean, as a matter of common sense, the privacy interest is gravely different, isn't it?
It is, yes. The privacy interest is certainly more than breath. But I would refer this court again to the Vernonia case, under which urine testing can be done in a situation where it's no different than using a public restroom, which people do all the time, obviously. And again, if you're one of those people who can't use a public restroom, you just can't pee with anybody anywhere near you, well, then you have the blood test option. And you have to analyze this case under the law as it now stands. If the law changes, then the analysis might change. But under the law as it stands now, there is no necessary invasion of privacy because this court can provide guidance on how urine testing should be done, because there's no case before us where urine testing has been done in an offensive way, and because you can always opt for the blood test instead. What appellant's really asking you to do here, and I think this is striking, not appellant, I'm the appellant, the respondent.
Counsel, let me ask you a question. I want to follow up on the Chief's question. You know, all three types of way of attaining blood alcohol level are searches. The Supreme Court's held that: breath,
right,
blood, and urine. And so I guess, you know, I've been thinking about this, and I'd just be interested in your response. When we're doing the search incident to arrest, or I guess when we're doing reasonableness, it's a different issue, but when we're looking at the exceptions, does the amount of the privacy or the nature of the privacy interest already really matter? I mean, the fact of the matter is they're all searches, and so why does the intrusion matter under a search incident to arrest analysis, or some of the other exceptions like exigency?
Well, I think under exigency and incident to arrest, it might not matter, because you could deal with a flagrantly unconstitutional factual situation under different grounds, just like you would with a massage parlor case. I think when you get out of incident to arrest, like in a blood case, then it certainly factors into the balancing. But my argument here is that this is like breath, and that it's merely collecting and naturally expelled biological material, and so therefore it should be considered a search incident to arrest. And if an officer makes you do it in an inappropriate way, we can deal with that. There was a mention today about peeing on the side of the road. Well, if it's the side of the road in the middle of a rural area at 2 a.m., and the reason it happened is because the driver said, I'd rather not go to the station house, can we just do it here? And the cop says, well, there's nobody around. Sure. Well, then that's not necessarily a problem. You'd have to look at it on a case-by-case basis.
So are you referring to the doctrine of outrageous government conduct?
Yes.
Okay.
If there was outrageous government conduct, like in a massage parlor case, or if you were forced to pee in a way that hundreds of people could see you on the Jumbotron, that would be a problem. But we don't have anything like that here. And again, we're talking about criminalizing test refusal. We're not talking about forcing you to pee. If you don't want to pee, you don't have to, but you've now revoked your implied consent, and you can be criminally punished for that the same way you can be civilly punished for that, and the same way that could be used against you in a criminal trial under Neville. What appellant's asking you to do here is, what Mr. Thompson's asking you to do here is say that it's okay to, under the Constitution, to lie to drivers. Because he's saying it's okay to tell them that test refusal is a crime in the hopes that they will then consent, but then you can't actually treat test refusal as a crime. But that cannot be squared to the McDonald decision, where you said if you tell someone test refusal is a crime and it wasn't because of their driving history, then their consent is no longer valid. So you can't square the result that he's asking for here with Brooks and with McDonald. What happened here was reasonable. It was reasonable under the balancing test that you have to apply under Knights. If you want to go to special needs, you can. The special needs cases do not say this can never apply in a criminal context, but you don't need to go that far under Knights and under the DNA cases. There was a question here about a state constitutional argument. Well, any state constitutional argument has certainly been waived by not being briefed. There has never been any claim that Minnesota has a unique history regarding implied consent, much less any evidence of some sort of historical basis for treating the state constitution different than the federal constitution. So that isn't before us. Again, Bernard recognizes the validity and importance of test refusal laws, and I think it'd be remiss of me to not mention again today the important interest we're talking about. Drunk driving kills thousands of people. In Skinner, a regulation was approved after 25 deaths. We're talking about hundreds of thousands of deaths nationwide, thousands in Minnesota, many more people injured. It's one of those crimes that you can't really protect yourself against. No matter what neighborhood you live in, no matter how careful you are, you could be killed by a drunk driver. It happens all the time, unfortunately, and Minnesota has chosen a very reasonable way to fight that and has put drivers on notice that if you choose to drive and you're lawfully arrested, that is the critical component here, you have to give a test, and if you don't, you're going to be criminally punished for it. And Brooks says it's okay to tell people that. If it's okay to tell people that, it's okay to do it. I think those are the main points I wanted to make. I do want to close with one additional point, which is if this court decides that test refusal is unconstitutional for either blood or urine, that is going to be a radical change in the law and in the way police practice, and the legislature is going to have to act. So I would urge this court to make any such ruling prospective only. That's what this court did in Henning, the whiskey plates case, and that's what it should do here. But ultimately, this court should hold that test refusal can constitutionally be criminally punished.
Well, that's an interesting twist you just threw us at the end. In other words, if we hold the law as unconstitutional as applied, the two folks before us today would get relief, but your argument is we should declare that no one else gets relief?
Well, you should do what you did in Henning, which I believe is if it's been properly preserved in any cases that are still out there, then that's okay. But in terms of someone who was arrested 10 years ago, 5 years ago, or never challenged anything or pled guilty, as in the Trahan case, then it's too late for them.
Has the subject of prospective or retrospective application of any holding by this court been briefed by either side?
No, it hasn't. The Henning case has been cited, and I'm asking you just to do what you did in Henning. Thank you. Yes, please.
When you say the legislature would need to act, what are you envisioning?
Well, for one thing, as the statute currently stands, you can't ask for test refusal and only then get a warrant. That's part of the big problem here, is that you'd have to get a warrant in every single case. The legislature may well want to change that, so you could ask for test refusal and then, if they refuse, only then have to spend all the time and effort to get a warrant. So that would be a change. The implied consent area is quite complicated, as this court knows, in terms of when you can invoke the implied consent law and what happens then and what drivers are told. It does seem to me that it would be problematic to tell drivers test refusal is a crime if this court has held that test refusal isn't a crime, but currently you have to read the implied consent advisory as it's written. So presumably then the legislature would have to change the implied consent advisory so police aren't routinely lying to drivers and telling them something's a crime that isn't. But then you have, that conflicts with Brooks seemingly, so it gets very complicated. Thank you.
Thank you, counsel. Thanks to both counsel for the help that you provided to the court in this case. This matter is submitted. We'll issue an opinion in due course. We're in recess.